In the information age, information is the coin of the realm, and that data needs to be secured and protected. And policymakers have increasingly turned their attention to that. And so today we'll turn our attention to the GDPR and what it means for your companies. To do that, we have someone who is, as I mentioned, a friend, a global expert in this space, and in fact, a great American story herself. She's a first-generation American. She goes to Princeton to become a civil engineer, but figures out she's in love with the law, goes to UCLA to get a law degree, and then finds her way to a little company called IBM. You may have heard of it. Works her way up to become vice president of security, chief privacy officer of IBM, before jumping to a world-class firm, Hogan Lovells, where she now leads the cybersecurity and privacy practice there. If you are a thought leader in privacy in the United States or security, you have already met Harriet Pearson. She's on the advisory board of EPIC. Many of you know EPIC, Electronic Privacy Group. She's on the ABA task force on security and privacy. She's on the Georgetown University, do I have that right? Let's see, co-chair, in fact, of Georgetown Cyber Law Institute. No wonder that she has earned a nickname in town as the First Lady of Privacy. Please join me in welcoming my friend and expert, Harriet Pearson.
I can tell Phil put a lot of work into that introduction. Thank you. Good afternoon, and I hope you had enough to eat, and I know you're interested in the GDPR, and what I want to do today with you all is give you something you can use on your way home. You're here, I understand, because many of you have technology-related jobs, management-related roles, and there's not one person and not one organization that I know that is anywhere near international that does not have some need to understand the GDPR and what it will mean for your organization. So just to get right into it, what I'd like to do is really give you some context for what drove the GDPR and what's in the what's motivating the European regulators and how we'll likely see this roll out. But also then really get concrete about what does it actually mean. And I'm not gonna talk for an hour, I'm gonna talk for about 20 minutes, and then we'll do a back and forth. So please store up your questions. I am gonna go through a little bit of content here so that the nice person with the camera gets a little bit of footage for whatever it is that you will use. And then we'll break it into whatever's of interest to you in the GDPR. May 25, 2018 is the day this regulation takes effect. Nothing magical will happen that day, but it is a date on which things change. And what the GDPR really is a regulation that was passed actually a few years ago now, kind of reformed a few years ago. But what happens in 2018 is that it takes effect absolutely across all of the EU. It's very much unlike current European data privacy law. I've been helping companies implement data privacy compliance programs since 1995, around then, which is when the EU adopted what's currently known as the EU Data Protection Directive. The difference between the regulation and the directive is that the directive was passed at the upper level, the EU level, and then it took many years for it to really be implemented in all member states of the EU. And then when it was implemented, but the penalties weren't very high. And so we've all those operating in Europe have adjusted to it, but the GDPR takes effect immediately as a regulation across Europe all at once, and as you'll see, the penalties are pretty high. We'll go through and talk about kind of its operational effects, but the other thing to point out is that it does have these enormous fines associated with it, and that's really caught the imagination of anybody who's caught by the GDPR, anybody to whom this is applicable, is that it comes with a much higher set of risks associated with noncompliance. And we'll get into why that weapon of having the ability to enforce is so powerful at this point, given the kind of intersection between companies' data strategies and breach notification, which is another kind of vector that comes into this, and then the fact that you now have regulators motivated with the power to fine. So that's what we'll kind of walk through this. So what's the aim? This convoluted highway system is a depiction of what it's like now, or at least what it feels like to have European privacy law implemented with a directive here, and the member states all having different laws. The motivation behind the GDPR is to get from this little highway system to that. That was the stated motivation. And in some way, shape, or form, I think you can argue that the GDPR is going to do that because it's going to be one EU-wide set of rules. The challenge, of course, not of course, but what is the case is that the GDPR establishes, it's not the ceiling, it's actually the floor. It's like here in the US, we have this notion of preemption, and the federal government passes a law and says, okay, states, you can't pass laws anymore in this area. That's really very rare. We rarely preempt the power of states or commonwealths to enact laws that they believe are necessary. The EU has done the same thing. So while the GDPR sets a baseline that's uniform across Europe, it's actually only a floor. So member states can actually do more. So, that was the motivation. So it's a single set of rules on data protection, valid across the EU. And the reality is that, you have that aim, but in order to get the uniform set of rules, what you also have done is you've got to get kind of a focus on, well, is it applicable enough? Is it broadly applicable? And so the member states, Germany disagreed with the UK disagreed with Italy. There's kind of been disagreement, and so to create one single regulation, there was a lot of compromise that had to happen. And part of the compromise really became, okay, we got to agree on what the reach is, and they went to a place where there's actually a fair amount of applicability that's extraterritorial, that the reach is across and outside of Europe to capture organizations that are addressing employees or addressing people in Europe in their operations. The aim really in a world where, as Phil said, data is really an asset, is the European approach is let's take a law and really bolster the ability of people to be in control of information that relates to them. That's another motivation behind this. It was said by the policymakers working on the regulation that their other aim was to simplify compliance. They really wanted to focus on helping companies and other organizations that have to comply with, putting judgment and flexibility in their corner. I think as we wrestle with what that really means, I don't know what folks will think about whether it's really practical the way it approves, but there's actually a fair amount of flexibility on how to get things done in it. And there was a real motivation to increase the enforcement powers, as I said. It took a long time to create. As is usual with policy changes like this, it took 5, 6, 7 years. People have been talking about it. This, in one fell swoop, replaces the directive that's been in place since 1995, so that you can do the math. It took a very long time to create this new approach, and it's very long, and it has a lot of recitals in the front, and then it has the actual articles. The recitals are just as important as the articles because they really are a key to understanding what it means, and that's it. I mean, it's one little book, and then it will be interpreted in a lot of different ways, particularly by a EU-level body called, right now, the Article 29 working group that will be now under the regulation, a newly formed group at the federal or EU level that will be issuing guidance after guidance after guidance to help organizations interpret what this means. And there already have been a number of guidance documents issued. There was recently a guidance document issued on, for example, what breach notification might look like under this and kind of the regulator's point of view. So lots to look at there. The first place to start, obviously, is to actually figure out if the GDPR is applicable to your own organization. And we've been spending a lot of, my colleagues and I should say I'm part of an international team of lawyers. We focus in this area. We have a very large team, and we have a lot of lawyers in Europe. So I'm really kind of play acting a European lawyer. I know enough to design and ask questions and kind of run a compliance program. I'm not a European lawyer, and the European lawyers who really go deep in this and look at the foundation of European law and how to think about it and apply it are my colleagues who are helping companies where maybe it's a close call. Maybe you don't have any operations in the EU. Maybe you just have a website. Maybe you just have apps. Maybe you want to branch out into Europe and you're looking for the structure that might be useful for your organization. Does the GDPR apply to you? The idea behind it is that it used to be under the directive, current law, is that you have, if you have an economic activity and you have an establishment and a couple of other things, okay, the directive or the laws in Europe apply to you, but there you have a vast array of web-based businesses because they can look at, we don't have physical presence, it's not related to the business that we have on the web. They can kind of say, well, European privacy law does not apply. One of the main motivations of enacting the GDPR was to put an end to organizations being able to say, no, European privacy law does not apply to us because we're not on the ground, we're not engaged in business. This law, this regulation is intended to be extraordinarily broad in its applicability. So if you offer services to individuals in the EU or monitor their behavior online, there's a good chance that there's might be applicability. And we're working with a lot of companies now to help them figure out how far does that go. So it could be a close call for some companies, but for most, if you have an office in Europe, if you have business underway, if you're targeting EU individuals, they're probably covered by it. I was working with one organization that was a nonprofit, and they found out that they were taking donations. They were taking donations from individuals in Europe who liked their cause, and they're based here in the US. They liked their cause, and so they were just sending them money. And they said, oh no, are we covered? Do we have to give the money back? Do we have to set up compliance programs? It was a big question because they said, well, we have a data privacy program, we don't spam, we have marketing protocols, of course, but do we really need to set up an EU style? And we looked at it, and it was, there's a way to say, well, no, you're not really targeting EU individuals. You're not marketing to them. You're not online profiling them. If they choose to send you money, that's not, and you don't actually make an effort to get it, okay. Good argument that the EU law does not apply to you. But as soon as you start sending them mailings and saying, thanks for your donation, come and visit us, or we have an event, and send some more, boom. You're under the law. So it was sort of a behavior-based analysis, and I'm using the nonprofit example to show you that even a nonprofit would have to do this. And so there's a gradation here that just to be aware of. So let's assume your company is covered. And how many of you are involved right now, or at least aware of your company's efforts to get ready? So the whole audience, camera. It says that they're involved in this effort, and I suspect you see pieces of it, right? If you're a developer, if you're in charge of a particular product, you probably see what your customers might be asking or how your company might be setting up a compliance program as it relates to your part of the organization, or maybe you're involved in the whole thing. So what does the actual regulation ask you to do? So it can be divided into some buckets. First is the notion of getting consent from individuals when you collect information about them. In a sense, this is not anything new. Privacy law in the EU, the US, and elsewhere has this concept of, before you collect information about me, let me know that you're doing that, but also get my permission if you intend to use it for purposes that are not associated or they're not consistent with the first purpose I gave you. So I'm here, and I would like to share with you a certain, my address. And I will share my address because I'd like to have something mailed to me from this event. But if you then take my address, bundle it up, and sell it to a third party, I should consent to that behavior. That's the action, that's consent. And privacy laws all over the world require that in some way, shape, or form. What the GDPR does is put some conditions on it that are a little higher, that are higher level or higher bar. So it has to be clearly gotten. You know those opt-in boxes that are pre-checked? That no, you can't use those. If you want to say, I want to give you this service, in order to get this service you need to consent, that's really not allowed either. The free services where it's like, okay, you can use it, and your choice is, well, don't use it. That's not allowed either. So this notion of consent has become more demanding and more widely required, but you don't always need consent. You don't always need consent, but it's particularly if you're going to share the information or you're engaging something sensitive. Transparency is another concept. You know, how do you, under privacy law around the world, if you're going to collect information about me and do something with it, I should have knowledge of it. That notion of I need a notice, and that's why whether you're talking websites or apps or anything else, you have so many of these. Now they've become very lawyer-like. These notices. They started off when I first started working in privacy. It was really simple. You should, you know, the notion was back in the 90s when the web was born. You really ought to tell people what you're going to do with information on the web. And so these privacy notices were born out of a good intention to say, hi, welcome to my website. You can browse here and I won't collect stuff from you, but if you choose to give me your name, I will be doing the following things with it. That's like common sense. And now these notices have become really long and complex, but the notion is still the same. And the GDPR requires transparency and they require notices. And in order to make those notices effective, the regulators in Europe have prescribed conditions, or they've said what these notices need to have. So any company that currently has notices on their websites or their apps or in other documents to their own employees internally, they're going to have to take them through a test to see, all right, are they sufficient now to meet the requirements of the GDPR for such notices? And we're doing a lot of that kind of scouring through and updating and editing companies' notices to get them to be compliant with, are you identifying who's going to be receiving the data, for example? Are you going to be disclosing that you're going to take the data outside of the EU into another jurisdiction? That's a hot button item. And it's specified here that you need to do that and say, information that might be collected about you, person in Europe, might be or will be taken or accessed from an outside Europe, particularly the United States. They might, you might have to say from the United States or from a jurisdiction that does not have equal protections as Europe does. So that's a important point. You'll have to say how long you're going to keep the data. I retain the data until I no longer need it. Not such a great statement. I retain the data for a period of time and then we dispose of it, for a little bit better. But those are the kinds of changes. How many people have heard about the right to be forgotten? Yeah, this one is really sexy. And it was a French regulator who came up with this. And he started talking about it, I want to say 15 years ago. And the first time I heard a lecture, or I heard him talk about it, I thought, you got to be kidding. You got to be kidding me. It was really clever, the framing of it. And it's actually, when you kind of think about it, I can understand why it is something that, for public policy reasons, it's actually becoming more and more attractive, I think, to all of us. If we think about it as individuals, in a world where there's so much information, that information is always there and it's going to be around for a long time, wouldn't you like to have at least an ability to say, could you please erase that? Erase, it's no longer relevant. It's information about me, but can you just get rid of it? This right to be forgotten has kind of gotten the imagination going, and it's also called the right to erasure. And this is the right of an individual to knock on the door of an organization and say, you have information about me. I would like to ask for this to be erased, for you to eliminate it from your databases and public display, because it's no longer necessary for whatever purpose you have. It's no longer necessary. I do not consent to it being displayed or used anymore. And here are these other 2 points: no overriding grounds and or unlawfully processed. There's a kind of a balancing test. There's a balancing test inherent to exercising the right to be forgotten from an individual's perspective. The company has to weigh that request against, do I have a legitimate reason for this? Is it lawful for me to process it? Is there some kind of overriding interest, like public safety or law enforcement issues or something like that? So there's a balancing test. It's not an absolute right. And as you can see on the right-hand side, unless, there's a lot of reasons why you say, well, no, you cannot have the right to erasure. For example, there's public health reasons. You have a health record. There may not be the ability to erase your health condition information if it's in the registry for health reasons, for public health reasons, as an example. So this is a right that is important. It's new. It is not absolute. It's not as sweeping as it might appear to be initially. But it is something that if your company is subject to it, and I would think most organizations, if they collect information, they have to think about at least, will a consumer, will an individual be able to move forward and ask for this? We've got to have a thought process about how do we handle these requests, and operationally, how do we actually execute on it? And a lot of the work that I'm seeing now, a lot of the questions from our clients involve how much work do we have to do? What kind of designs do we put in our products to wipe the data? And do we have to do it in the backups? Do we have to find all the possible places where the data is cached and stored? And do we have to wipe it all out? And so how granular does this right to be forgotten have to be implemented is a really, really interesting question. It's a hot question. And right now, there's no authoritative answer, because nobody's actually really opined on it. The regulators haven't said, although if you ask any regulator pretty much in Europe, they're going to say it should be erased everywhere, absolutely everywhere, which is actually kind of hard. And anybody here who's technically proficient and understands how computers work, or cloud and all this other, you're gonna kind of tell me how difficult it is. And that's really the game we're playing right now. That's the back and forth, which is, on the one hand, I can tell you what this says, then you tell me how hard it is, and then we come up with an answer about what actually practically you can do and how you defend it against what the European regulators might say is required. There's also another right in the GDPR that has to do with profiling. Profiling is a word that has all sorts of connotations, but it has to do with high-risk profiling. And this is kind of tied to AI, artificial intelligence. It's tied with the use of a lot of information to come up with conclusions or assertions about an individual and their proclivity or their behavior. And the right here is, there's a suspicion about making decisions about a person based only on automated decision analysis. This has deep roots in European history. It has deep roots back to World War II and the ability of Nazi Germany to process a lot of information and spit out insights about populations that were targeted. Bad history and a lot of emotion around having control and protection against such automated decision making. That motivation is behind, in the US, the Fair Credit Reporting Act, which says, you can't deny someone a job because of their, you can't deny someone a job or financial credit or other kind of financial access based on only a check that is not somehow regulated. So this is not an unusual motivation. This right is you have to have some human intervention and some other protection around the use of this kind of profiling. So the questions we're wrestling with here is, what does high-risk profiling look like? What does it mean? And how do you distinguish it from quote-unquote ordinary profile, where if you're on a website, you say, okay, so people who kind of do this, well, they get this display, or they get, this display. That's really not high-risk profiling. And so the question is, what's high risk? Clearly, when you're dealing with health information or access to important financial information or employment decisions, that's probably high risk. And if you are dealing with those kinds of decisions, you just have to put in more steps and really think through the process you're going to use, and other things you don't. Next piece of the GDPR, which is driving, next to the fine structure, is driving a lot of work to demonstrate that a company has taken this seriously and has put in place a program to comply, is this notion of accountability. And I think in most contexts that we're familiar with, if you have a law that says you must do things, you kind of assume, all right, that means I have to do things, and so I now need to go implement it and comply. What the GDPR has done is say, not only do you need to have these steps and do these steps, but you also are required to show that you've put in place a compliance structure. And then they've actually specified what needs to be in that compliance structure, or what's evidence that they would say is good evidence of what compliance or accountability looks like. This is really a really significant change. And so here's what the regulators, or actually the law, the GDPR says you need to have. So you need to have in your company policies that talk about data protection, which is the European word for data privacy, more or less. It's kind of the equivalent. You need to have data protection policies. You need to show that you think about data protection or data privacy as you make products, as you work through the company. You have to do it by design. And you also have to put privacy in by default, which is a really thorny concept. What do you do to embed privacy thinking into your company by default? Really tough when data is the coin of the realm. And so it's sort of its intention, but it's part of that. You have to keep records. You have to take an inventory of what kind of data do you collect, who are the entities with whom you share the information, who are the vendors or the so-called processors, the entities that might take information or access information, who do it on your behalf. Who are they? What kind of data do they have access? So you can what we're seeing companies do now is actually create spreadsheets. There have been companies that have emerged as, you mentioned a GDPR tool. I mean, a lot of companies have GDPR tools now that say, we will help you with your compliance. A lot of what they're doing is they're helping you create inventories. They're helping you automate the maintenance of these records of processing. And a lot of the questions I'm getting are things like, how granular does that record keeping have to be? How often do we update it? All those, I think, are still TBD. All I would say is that, I would say don't get too carried away. You don't need to be so exhaustive that it creates a humongous or huge burden on your organization to maintain evidence of every digit. But then don't go over to the other side either, which is to say, well, we collect information and it's kind of this and that. Well, that's not enough either. So it's somewhere in between. And yet it's a matter of how sensitive your operations are, what kind of company you are, and all that. But record-keeping obligations, you need to keep an open book and be ready to be inspected. That's actually quite disturbing for most of the companies I work with, which is if a data protection authority knocks on your door, it's like having a environmental protection agency or a workplace inspector come and, or OSHA inspector come here and say, I'd like to inspect your books, please. A workplace inspector, an OSHA inspector knock on the door, audit, you got to open the door, more or less. In Europe, you're going to open the door and say, okay, data protection authority, here's my data privacy compliance, here's my record keeping, blah, blah, blah. This is a right enshrined in regulation. And that changes, I think, the game a fair amount. And that's one reason, another reason why this is now, more serious kind of regime. And it applies not only to the controllers, i.e. the companies that actually control and take data and actually make decisions about data, but it also applies to processors. Like a lot of tech companies, cloud services companies are processors because you handle information on behalf of somebody else. You host it, you process it. You don't make necessarily the decisions about what happens to information about HR data or sales data. You're doing something on behalf of your customer. You actually are required to comply with these and demonstrate that you would have these record-keeping obligations met, and you would open the door to cooperate with the Data Protection Authority, processors also now have to comply with the requirement to notify if there's a breach. Processors have to notify the controller, the customer, the endpoint, or the accountable agent for the data. And then, just like there is in the United States, if you're a company and you have information about people and it is breached, compromised, you now have to report to the Data Protection Authority, to the regulator, who may then ask you to report to the individual. So this is an important change in terms of the data breach notification requirements we've gotten used to in the United States. You go right to the individual. And we've all gotten those letters that say, I'm so sorry, to let you know that there's been a breach. And you kind of look at it and say, okay, and then the company, if it has a big breach, they might get sued. It'll be in the press. Here, I think what we'll see happen is much more frequent notification to regulators. What happens then is probably, it doesn't become public necessarily, but the regulator will use it as a sign that says, oh, I must need to visit that company. Please show me what you got, and let's have a conversation. So it's a much more enforcement or regulatory kind of discussion in Europe. Here in the US, breach notification is much more litigation-oriented or public crisis, public opinion-oriented. Prior consultation, you have to do, show evidence that you've done data protection impact assessments. If you have a new product, a new process, have you thought about the impact on privacy? And have you documented that assessment? It's a little bit like doing an environmental impact assessment, if you know the environmental regime in the United States. Before you build a big road, a big bridge, there's a national federal requirement for somebody to do an impact assessment on kind of the environment. And this is kind of conceptually the same thing, except all of us who are creating a new product or a new way of using data will have to go through a process like this and maintain a record of it. That's actually mind-blowing. I used to run this kind of program for a very large multinational, and I kind of, the scale of something like this, if you actually did it for everything, is enormous. So really the practicality of it is going to be on, what actually do we need to do, how, on what scale? Can we do it once for a kind of a whole set of products or a whole set of processes? How do we kind of put it all together is going to be, I think, a big task. And a few others. We don't have time to go through it. So this young man is, his mind is like getting all sorts of signals, and is kind of getting overwhelmed because I talked about privacy by design and by default. And really, a lot of this, I think, is going to be somewhat rocket science-y. Because, when you think about privacy by design, you can not collect data. That's probably not a very satisfactory thought. But you might, if we're talking about personal information or personal data, as the Europeans call it, you might try to pseudonymize it, which is to kind of go almost all the way to anonymity but stop short. And the science and the kind of techniques about how you do it is going to be part of kind of thinking about how you show that you have thought through it and designed something by privacy by design or by default. I'm going to kind of go through quickly a couple of other things because we're running short on time. I talked about the data breach notification. There is an affirmative obligation in the GDPR to have reasonable security. Enough said. I mean, have reasonable security. There's already U.S. law that requires that. It's embedded in our law, kind of common law. Massachusetts has a requirement of all states. I mean, Massachusetts has the leading state general information security law. Europe law now says you must have reasonable security and you have to notify within 72 hours, oh, by the way, if you become aware of a risk. If you are using vendors, and some of you are vendor companies or processor companies, the contracts that you have with those vendors need to have specific items in them. You have to flow down requirements. And the vendors themselves, the processors, are now directly responsible and liable for their actions in handling that information. You cannot say, I'm just a vendor, I just did what I was told. In Europe, under the law now, the requirements go right to the vendor themselves. That's a huge change as well. And what hasn't changed very much is the continuation of the obligation to get permission to access personal information from outside Europe. Or as you could also say it, to transfer information. But you really don't physically have to transfer the information. All you have to do is access it from someplace else, and that's equivalent to a transfer. That hasn't changed. It's been the same now for a while. There have been some legal turmoil over how to do it, but basically the obligation remains for putting in place either contracts or a privacy shield, getting into the privacy shield or kind of the equivalent approach to legitimizing access of European individuals' information from the US or from other countries. That also has its own set of challenges and its own work to achieve. The enforcement here is still going to be done by the national regulators. They are getting together in Europe and cooperating, though, and sharing information. They are trying to arrange for a one-stop shop for some companies who choose to use a lead regulator to try to cut down on the potentially inconsistent approaches. That approach has to be still ironed out because it's really cuts against the grain of regulators wanting to do their own thing. And then we talked about the higher fines, which go up to about 4% of global revenue. So it's not just the European revenue, but global revenue, which is what a lot of folks focus on. In terms of practical takeaways, and I promise this is like almost the last slide. So what do? This notion of being accountable and demonstrating that you've done enough. This is a good slide to take pictures of. I notice people are taking pictures of some of these because if I just had one slide to say, what do you do now? This is the one, which is, okay, so if you have policies or programs that are about governing data, that are about retention or classification of information or BYOD or background checks, every single one of those existing policies needs to be reviewed and updated if you are doing business in Europe and you're caught by the GDPR. You can choose to change your policies globally to fit and comply with Europe, or you can choose to just do a European flavor and version of these policies, whatever suits your operations. But if you're going to be caught by the GDPR, these are the kinds of policies that need to be changed or need to be adopted. For example, privacy threshold and privacy impact assessment. You may not have that kind of policy or procedure in the US, but you would need to put something in place. Breach notification, chances are most companies in the US of any size have now developed incident response plans for breach, if a breach or a compromise might occur. They've got a way, you got to report, you got to escalate, you got a team. What companies are doing now is they're internationalizing their breach response plans. They're creating either a European version or they're taking their existing, for US-based companies now, they're taking their existing US plan and they're tacking on a chapter for Europe or a way that they're going to deal with Europe. So on and so forth. And whatever training you have, adopting it and adding to it. And I could go on, but that's what you're going to be working on. And this is just an actual sample of, probably this is about several months old now. We're working with a client, and the client, when we left a work session, we just jotted down the major work streams. So this is an actual sample of an anonymized company and said, okay, what are we doing now? We can't do everything at once. If you look at this, you could probably dream up 50 actions, 50 work streams, and you can't do that. So how do we prioritize? And this is an actual company's prioritization, just as a sample of a reality check. You're not going to do everything at once. What are they doing? They're trying to figure out what data they have. They actually have never looked at exactly what kind of personal data they have, so they're actually inventorying it. They're trying to figure out a way to maintain a record of it. They thought that their internal and external privacy notices, they could easily tackle that, so they put that up toward the front. They really wanted to start with the vendor agreements that they have to update and change, because anything having to do with a third party is going to take some time. And they wanted to get out a little bit ahead, because they knew that if they didn't go out, they probably would get boilerplate from their vendors, and they wanted to go out proactively. So they put that up in the queue so that by May of next year, they have a shot at actually updating enough contracts. And then you can see some of the rest of it. So that's overall plan of action. Figure out if this applies to you. It may not. which would be great. But if it does, review the data that you have, review whether you need to get consent for certain uses and how you will achieve it. Look at your notices and transparency mechanisms and figure out what needs to be updated. What else is going to be an impact on your operations? If you have, a data breach plan, expand it to Europe to figure out how you're going to deal with evidence of a compromise there. Above all, this is about a certain type of data, personal data, which is very broadly defined in Europe. There's value in that data, there's utility to it, and in a sense, what Europe is trying to force us to do via the GDPR is to really mature the approach we take to its management. So in a way, to try to make lemonade out of maybe a certain amount of lemons, we are really focusing and helping our clients to focus on, look at this as an opportunity, if you can, I think most people who work in my field have had a sense for quite a number of years that there's kind of a right way to manage data and deal with data that's about people. We've got to keep it secure, obviously, but there are certain ways people want to be treated with respect, with transparency, and so this is really a kind of a forcing function to do something that probably over the long haul will make it more sustainable, that we will continue having permission from each other to share as much and use as much as technology is allowing us to use. So you could think about it as an opportunity to choose to look at it that way. So those are some prepared remarks on kind of key points to know about GDPR, and now I'd like to open it up for questions and thoughts.